everyone. Late evening क्या चाय पे चर्चा type. We are bringing you the entire legal reasoning section and all the questions of legal reasoning is something that we will be discussing through the course of this session, right? So I hope everybody is all geared up and you definitely want to know the answers of all the legal reasoning questions. Let's jump right into it. Here is our answer key, of course, right? We've all worked decently hard enough to try to figure out what could be the best possible answers. I hope that the AILET is not going to be as much of a wrong answers kind of a crisis situation, which which CLAT was. Most of the questions seemed pretty straightforward, just a few here and there which I thought needed a little bit of application of mind and quite a bit of decisiveness and so on. But most of the questions overall, most of the questions seem to be pretty straightforward as far as the legal section is concerned, right? Okay. As always, before we jump into the actual questions, quick announcements. Today is day 2 of the Mission Possible sale, and you can of course use the code Mission50 to get a flat 50% discount for all our courses, including CLAT 2022 as well as CLAT 2023, which we do both English as well as bilingual courses, which we have launched, right? So I know all of you are really waiting for all the correct answers. So I'm not going to waste too much time and I'm going to jump right into it so that all of you guys can definitely make the most of what we believe are the right answers. Okay. Payal, Shubham, Rinisha, Yashasvi, good to see you guys. Ashutosh, Kamaljeet, दिया ही नहीं, अरे 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 दिया ही नहीं है तो okay. So we have the first question right in front of us. Which of the following positions is not provided for in the Constitution of India? Which of the following is not provided for? Under Article 76 of the Constitution, we have Attorney General of India. Under Article 165, we have Advocate General of India. Under Article 316, we have the Chairman of the Union Public Service Commission. बीच में कौन छूट गया है? Solicitor General of India is not a constitutional office. It is not provided for in the Constitution. In the Kulbhushan Jadhav's case, coming to the next question, between India and Pakistan before the International Court of Justice, the 15:1 majority found Pakistan to be in violation of which obligation or which instrument of international law? It is the Vienna Convention on Consular Relations. It is the Vienna Convention on Consular Relations. Very popular case, right? Very popular case, which I'm sure all of you have read about, right? But unfortunately, if you missed out on the exact law is the Vienna Convention on Consular Relations. 72 option A is the right answer. Who among the following was not a judge of the Supreme Court of India? इसमें से 3 लोग सुप्रीम कोर्ट के जज थे. Justice Manjula Chellar. Justice Manjula Chellar was not a judge of the Supreme Court. She was the first Chief Justice, the first female Chief Justice of the Calcutta High Court, as well as the first female judge of the Karnataka High Court, but she was not a judge of the Supreme Court of India. The other 3 are, of course, honorable judges of the Supreme Court. Honorable Justice Manjula Chellar was a Chief Justice, but not a judge of the Supreme Court of India. Okay. Who is the only judge of the Supreme Court of India to also have been the Vice President of India? In fact, very popular judge. There is one National Law University which is named after this particular judge as well. I don't know if you guys figured out the right answer from that hint, right? It is, of course, Justice Muhammad Hidayatullah, who was not only the sixth Vice President of India, right? He was the sixth Vice President of India, but also he was acting President of India twice, right? So this is a name which has been very popular and has been discussed in all of our constitutional law. I mean, not in every single lecture, but in all of our comprehensive course batches, right? I definitely make sure to talk about Justice Hidayatullah. I myself have studied at HNLU as well. So, you know, HNLU is Hidayatullah National Law University. Okay, so sixth Vice President of India. The sixth Vice President of India was Justice Muhammad Hidayatullah. Okay, who replaced Justice Ruth Bader Ginsburg on the Supreme Court of the United States? On the Supreme Court of the United States. So a long time that Justice Ruth Bader Ginsburg was a judge of the Supreme Court of the United States. In the US, you are appointed as a judge of the Supreme Court for life, right? वहाँ पर कोई retirement का scene नहीं है, right? There's no question of any retirement. You are there for life, okay? And of course, it is only after Justice Ginsburg had passed away that we had to, of course, I mean, we in the sense, United States. The nominee of the Trump administration was Justice Amy Coney Barrett, right? Justice Amy Coney Barrett was the Trump nominee who was ultimately appointed after the United States Senate made the final confirmation on October 26th, 2020. On October 26, 2020, we had the final confirmation by the US Senate. Okay, moving on. Basmati rice, which I'm sure a lot of you have had at your home, no? आज भी बना है क्या बासमती बिरयानी, जिसका एग्जाम बहुत अच्छा गया होगा, बिरयानी भी बनी होगी शायद. Is an example of what type of intellectual property? It is, of course, a geographical indication, right? This is something that we discuss in again in my lectures on miscellaneous topics like intellectual property rights, where we discuss patent, copyright, trademark, and Basmati is a specific example that I have definitely discussed in the classes. When I give you the example, for those of you who attended the IPR lectures, you might remember that this is one of those rare cases which India actually won in the World Intellectual Property Organization. Before the WIPO, India actually won the case against the United States. Basmati is one example. There's tulsi, which is basil leaves, and of course turmeric or haldi, right? Ye sare cases India had actually won in the World Intellectual Property Organization. Okay, moving on. In Part 8 of the Constitution of India, the Parliament is empowered to create local legislature and the Council of Ministers for certain union territories. Name the union territory or territories in India that have a legislative assembly and a Council of Ministers. Right? So सबको तो पता है Arvind Kejriwal is the Chief Minister of Delhi, right? And there's a very popular confusion. Delhi is not a state. Delhi is not a state. Delhi is actually a union territory. That is the NCT of Delhi, or the National Capital Territory of Delhi. Puducherry, again, very famous Lieutenant Governor in Puducherry, right? So a lot of you might remember. It is of course Kiran Bedi who was holding the Lieutenant Governor's office in Puducherry. Puducherry also has a legislative assembly, a chief minister, and so on. And most recently in August 2019, right, Jammu and Kashmir was converted. It is no longer a state, right? We partitioned J&K into Ladakh, two union territories, right? Ladakh became a separate union territory, and Jammu and Kashmir also became a separate union territory. Jammu and Kashmir will continue to have a legislative assembly along with the NCT of Delhi and Puducherry. So therefore, the correct answer is option C, Delhi, Puducherry and JK. Okay. Name the only erstwhile princely state in India that was allowed to have its own separate constitution on its accession to India. Very, very popular, very popular question. I'm sure everybody, and I hope everybody got the right answer to this one. Special status under Article 370 of the Constitution of India, right, is conferred on the state of Jammu and Kashmir, right? And that is the state which has its own separate constitution, used to have its own separate constitution when it was a state, at least. Ab to union territory ban chuka hai, right? Okay. Which of the following statements accurately captures India's position on torture? Well, I mean, when I first read the question, I mean, of course, India's position on torture is we are not in favor of torture, right? Except in like emergency situations or exigencies, and so on. India is, of course, a signatory, right? India has signed the UN Convention Against Torture, right? On 26th of June 26th, 1997, India has already signed the UN Convention Against Torture, but India is one of the very few countries which has not yet ratified the same. It has not ratified it, and therefore option B, Bombay, is the right answer. Right, okay. Let me take a quick look at the chat box. Okay, people are also answering along with us. 75.5 SC, kya chance kya hai? It seems just a little bit towards the lower side of things, but fingers crossed. Let's hope for the best. Let's hope for the best. Okay, so question number 80 onwards, of course, right? Question number 80 onwards, we did have legal reasoning questions, right? And the first question was in relation to the principle of bailment, right? Pretty easy question, honestly, if you think about it. Aparna entered into a contract, and Aparna gave certain goods to Gagan, right? Gagan kept the goods, and Gagan kept the goods at the same place where he kept his own goods, right? Where he kept his own goods. But he was still negligent. He was still negligent, and he left the window open, right? So the test, please understand that the test is in the principle is not just about whether he took the same care as his own goods. That's not the only thing. It is also about ordinary prudence. Was there ordinary prudence or not? Was there reasonability in the kind of actions that were actually taken? And Gagan's negligence in leaving the window open is not ordinary prudence, right? At least not in our opinion, right? ठीक है, अपने goods जहां रखा था वहीं रखा था, लेकिन negligent तो वो अपने goods के लिए भी था, right? So therefore, if you apply that additional test, we believe the answer should be option A. We believe the answer should be option A in this case. Okay, question number 81. This I thought was a little tricky, to be very, very honest, because of the language used in principle number 2. Right, of course, in our criminal law lectures, again, those of you who have attended our criminal law lectures, we have discussed the difference between the various stages, right? Intention, preparation, actual attempt, and actual commission, right? So if you're pointing a gun at somebody, there is no attempt. If you pull the trigger, there is an actual attempt. If you buy a gun, there's only preparation. If you go looking for a person, it is only preparation. You take aim, it is still preparation. You pull the trigger, and is normally that's what attempt basically means, right? But if you look at principle 2, here's where things got a little tricky. In order to be designated as an attempt to commit an offense, the act or series of acts done must be sufficiently proximate. There should be a close connection. There should be a close connection between between the things that have the preparation and the actual thing that has happened. Now in this case, somebody wanted to light something on fire. He bought a matchbox. He actually lit it. Right? But he saw that there is a camera, etc., and he decided not to commit the offense, right? He saw that there is a camera and decided not to commit the offense. Would this still amount to arson? We believe that this is a little bit of a gray area, but we believe the safe answer is option A in this case, right? Because ultimately, if you look at the actual concept of attempt, if you are in control, if you can still stop the crime from happening, if you are in control, right? ट्रिगर खींचने वाला एग्जांपल मैंने इसीलिए बताया कि ट्रिगर अगर खींच दिए तो उसके बाद आई एम नॉट इन कंट्रोल, राइट? आफ्टर पुलिंग द ट्रिगर I am not in control. So that's when attempt begins. Now in this case, even if I've lit the match, I'm still in control, and which is exactly what happened in this case. So therefore, because he's still in control, attempt has not happened is the safe answer according to all of us here at least. Okay. Double jeopardy. This question was very, very simple. Question number 82. Right, question number 82 was very, very simple. I don't think many of you who've given the paper would have faced, too many problems with this particular question. Departmental inquiry, disciplinary proceedings, etc. is not double jeopardy, right? Double jeopardy applies only and only when there is a criminal case, right? So दोनों केस criminal होना जरूरी है. एक अगर डिसिप्लिनरी प्रोसीडिंग है तो दूसरा क्रिमिनल केस है, तो दोनों हो सकते हैं, राइट? एक बार क्रिमिनल केस हो चुका है तो फिर से क्रिमिनल केस नहीं हो सकता, राइट? दैट्स द होल पॉइंट इन क्वेश्चन नंबर 82. एंड देयरफॉर if you look at the various options here, there was one disciplinary proceedings and one criminal case. Therefore it's pretty simple. Double jeopardy protection will not be applicable. Double jeopardy protection will not be applicable, right? Okay, Prakhar, I'm happy to this thing. Please do feel free to reach out to me at any time. Okay, question number 83. Question number 83 was again, I don't think it was a very difficult question. You just have to make sure the lesson to learn the lesson to learn from question number 83 is कि प्रिंसिपल अगर आपको दिख गया कि न्यूसेंस है और आपने प्रिंसिपल पढ़ना छोड़ दिया, if you did not bother to read the principle, the moment you saw the word nuisance, then there is a little bit of a problem, right? Then there is definitely a problem in this situation. Prakhar, I've dropped it on the chat box. I mean on the YT chat. Did you not receive it? I'm not sure. I'll just this thing again. In any case, like I was telling you guys, in this case, it is important to look at the second part of the principle, right? That is, it is no defense to a claim of nuisance to say that the plaintiff knew of the interference that would be caused. So even if I knew, I would still be able to claim compensation, right? So in this case, they knew that there is a cricket stadium nearby and they still build a house, but stadium के बाहर था. Stadium के बाहर था, तो there is a situation of nuisance, and therefore, right, the cricket club cannot claim that Mrs. and Mr. and Mrs. XYZ brought trouble on their own head. It is not an acceptable argument. Okay, so we are going with option B here at Grade Up. We are definitely going with option B, Bombay. 84. Very simple question. Very, very simple question. बस ध्यान से पढ़ना था. H entered his friend L's property because it was adjoining C's home. From L's garden. From L's garden, H shouts insults and tried to intimidate person C. So क्या वो H के घर में गया है? H के घर में ही नहीं गया है, right? H के property में ही नहीं गया है. So if the person has not even gone to H's property, right? H has not entered into the property of C. Sorry. In this case, H has not entered into the property of C. Therefore, the intimidation was from outside, right? Therefore, there is no question of any trespass, and I don't think this is something that I'm even guessing, or this is not. I don't think there's any scope for disagreement here. अब ये आंसर भी अगर AILET कुछ और देगा तब तो मतलब ज़्यादा ही हो गया in our opinion. Okay, is this bribery? Somebody needed expensive medical care, expensive medical attention. इलेक्शन के टाइम पे कोई नेताजी जो है पहुंचे, नेताजी ने जाके वहां पर बहुत सारे पैसे दे दिए उसको. उसके बाद जाते जाते पार्टी सिंबल को हाईलाइट करके गए हैं कि देखिए कमल निशान को याद रखिए, क्या नीला झंडा हाथी निशान, बसपा की है यही पहचान, right? I don't know, they sort of went ahead and highlighted the election symbol, right? Would this be acceptable, right? Would this be acceptable? This is obviously not acceptable. This is obviously going to amount to a bribe, right? And therefore option A is the answer that we are certainly gunning that this is the correct answer. 86 is okay. This is a very straightforward question. P was hunting in a small forest area which he knew to be inhabited by villagers. So if P already knew, right, and that it was frequented by other hunters also, in large numbers, even if his friends did not know, that makes no difference. भाई जो person गोली चलाया है उसे तो पता ही था ना, तो उसको आंख पे पट्टी करके अलग सुपर रॉक स्टार बता के starting to shoot people, 3 bullets, 3 dead. Yeah, that's definitely overkill, and that is definitely culpable homicide in our humble opinion here at gradeup. Okay, question number 87, a long winding question. This was basically that a particular company gave certain guarantees, right? But they gave disclaimers. They gave disclaimers along with the guarantee that, kitna electricity manufacture hoga, whether it will be around 50 lakh kilowatt per annum per turbine, or it will be a little lesser, depends on the wind, right? Depends on the wind, right? Energy is dependent on the availability of the wind, and they could not guarantee it. That's the stated position, right? They provided an estimate. Okay, so because it is dependent, there is very little chance of actual liability in this case. Very little chance of actual liability, and therefore our answer is, will the company be liable? No, because Windon clearly specified that the energy generation figure was merely an estimate that could not provide a guarantee. So could not provide a guarantee, not liable, right? Okay, question number 88. Okay, this was again a very straightforward vicarious liability questions. Any of you who have attended the comprehensive course lectures, right? Any of you who've attended any of our comprehensive course lectures, you know that we've discussed vicarious liability in quite a bit of detail, and the concept of course of employment is very straightforward. आदमी अपना जॉब खत्म करके घर जाके दारू पी के किसी और को मारेगा तो कंपनी लायबल नहीं होगी, राइट? देयर इज नो क्वेश्चन of the company being liable in this situation, and therefore, right, therefore if you look at whether the master is liable in this case, answer is obviously option C, the restaurant is not liable for G's actions. Now the next question was relatively simpler. This is during the course of employment, right, while he was working as a security guard, guests say नौकरी के दौरान ही, right, ended up because he was very short tempered, got irritated and ended up hitting one of the guests. Now this is part of the job, right? This is part of the job, and in this situation, the restaurant is definitely going to be liable in our humble opinion, right? Just want to make sure that we say this is not the actual answer key. This is our belief This is our evaluation of what the correct answers should be, right? 89 is option A. Question number 90. Let's move on. So again, this is something I really want to say it as clearly as possible, right? This is simply a direct application of the principle that is given. The principle does not require anywhere, the principle does not require that something needs to be physically removed, right? Physical removal का requirement कहीं पर भी नहीं है, right? I would strongly encourage all of you, those of you who have not attended my lectures on criminal law on the gradeup platform, please do attend the gradeup lectures on criminal law. Specifically, जब भी मैं theft discuss करता हूं, we do make sure here at gradeup that I talk about the difference between mental possession and physical possession, right? The difference between mental possession and physical possession. यहाँ पर mental possession से बाहर जा चुका है, right? मुझे पता ही नहीं है क्योंकि तुमने जाके कहीं छुपा दिया है. So will you be liable? 100%. We believe the answer should be option B, Bombay. Yes, W committed theft when she moved the ring, right? When she moved the ring. Now this question was something which I thought is a little tricky, right? R owns an antique watch but is unsure of its value. Takes it to the jeweler, right? Jeweler कुछ भी बिना बताए अपने घर ले जाता है उसको. अब वो चेक करने के लिए लेके गया कि क्या करने के लिए लेके गया, something that's a little undecided, right? But I would still think that ultimately this is not theft, probably, right? Again, like I'm already telling you, this is an answer which if NLU Delhi decides to go the other way, right, and they sort of assume that option A, right, it is possible to go with option A as well in this question. It could it could well be that it could well be said कि यहाँ पर बिल्कुल वो सामने वाले के possession से बाहर तो निकाला ही है, right? सामने वाले के possession से बाहर निकाला है, so I should say it should be option D, or assumed to be in possession of the jeweler. Again, I personally believe that there is no question of any such assumption, right? I believe that since the watch was taken without any explanation, right, वो अपनी मर्जी से randomly अपने घर ले गया, it is difficult, very difficult to conclude that the watch was actually in the possession of the jeweler, and therefore I believe the answer should be option D. But please note, this is a pretty tricky one, and it could honestly, it really sometimes it just depends on the examiner's perspective and what the examiner is thinking. तो अगर वो कहें कि नहीं explanation की ज़रूरत नहीं थी, वो assumed था, understood था, अब ऐसा कुछ होगा तो they might possibly change the answer. But I think it should be option D. No, this is not theft. No, this is not theft. Okay. Question number 92. Kritika's birthday, there's a piano. This is a very straightforward application in this question. For those of you who've seen the question paper, very straightforward application of a very simple concept. That is the concept of caveat emptor. Again, I invite all of you to attend the gradeup lectures, right? Contract law में misrepresentation, fraud, duty of care, ये सारी चीजें काफी डिटेल में हम पढ़ाते हैं, right? काफी डिटेल में हम ये सारी चीजें पढ़ाते हैं. So if you had just attended those lectures, I'm sure you would have gotten the absolutely correct answer, that the buyer here should have been beware, right? We believe the answer should be option C in this case. But again, sometimes यहाँ पर duty of care नहीं है करके कुछ हो सकता है, but unlikely option C seems to be the safest answer in our humble opinion. 93. 93 is probably the easiest question in the entire legal section. Probably the easiest question in the entire section, right? इसमें तो किसी का कोई भी गलती I am sure नहीं हुआ होगा, right? Okay, quite a few. So, okay, sir, this topic is CLAT 2022. Oh, Hemant, no, this is AILET 2021. You didn't see the title? This is for Abhilash. George, hi sir, hope you remember me. Exam was easy. Yes, Abhilash, I definitely remember you. Abhilash, and I'm very happy to know that your exam went very well. I hope you do get through, get a bomb of a rank and manage an awesome score and everything. Right, all the very best for your results. Lectures kaam aaye, I hope. Right, I hope the lectures were very, very helpful. A lot of questions, I think, directly from the class lectures that we had. I mean, at least directly in the sense that you could derive the answers quite easily if you just attend the list. This is, of course, one of the easiest questions I've seen in the history of AILET. Right, and the question is pretty simple. What's the question? Pretty simple question. Obviously, since the confession was made in front of a police officer, the confession is not valid. The confession is not valid. Option A is simple, straightforward, easy, and correct answer. Okay, question number 94. Aishwarya had rented a flat. Now, here again, if you just read the principle, very, very simple question. हाँ, जरा लंबा क्वेश्चन है तो मेहनत थोड़ी सी लगेगी, बट क्वेश्चन बहुत इजी था, राइट? देयर इज the tenant of an immovable property during the continuance of the tenancy cannot be permitted. You will not be permitted to deny that the landlord of such tenant had at the beginning of the tenancy a title to such immovable property. आप नहीं मना कर सकते, बाद में नहीं मना कर सकते. So if you have already agreed, Aishwarya has already agreed, Nidhi is the owner, Aishwarya cannot back out from that situation, and therefore option A, Aishwarya should pay the rent to Nidhi. Nidhi and Ashish can continue with their case. निधि और आशीष को अपना जो भी केस लड़ना है, जीवन में जो भी करना है, प्रॉपर्टी डिस्प्यूट सेटल करना है, वो करें, but Aishwarya has to continue to pay to Nidhi, and option A seems to be a pretty straightforward question, to be honest. Okay, 95 guys, 95. Again, there is if somebody already has a driving license, right? You already have appropriate age. You're already above the age of 18. The duty of care is with you, right? The duty of care is definitely with you. You should be in a position to verify कि बाइक चला रहे हो तो बाइक का क्या सिस्टम है, क्या नहीं है. ये जिम्मेदारी मेरी थोड़ी ना होगी, ये जिम्मेदारी बिल्कुल तुम्हारी होगी, राइट? यू आर एडल्ट हो चुके हो, बाइक चलाना चाह रहे हो, समझोगे तुम, राइट? सो Q has consented to the risk because he urged Z to let him ride the motorbike. So option C is spectacularly the correct answer in our opinion. 96, again straightforward question, right? Pretty straightforward question. This is clearly uncertain. 31,000 or 30,000. But how do we determine what the hell are you really talking about, right? So question number 96 is clearly an uncertain price issue. And when we're looking at uncertain price issue, of course, the agreement is void because of uncertainty. Direct application of the principle. Direct application of the principle. Now, 97 was a question which personally I thought was a little tricky. Again, this is probably the second question which I found to be a little tricky. Ultimately, I believe the answer should be option C. Ultimately, I believe the answer should be option C, because if you look at the overall agreement, it is about the sale of a bike and it is about the payment of an additional amount subject to performance, subject to providing a 60 kilometer per liter mileage. So if I'm trying to figure out whether we can split the agreement into two parts or not, कि bike का price तो one part है and additional payment is the remaining part. So even if the additional payment, right, even if the additional payment is something that can be in dispute, the agreement in relation to the bike itself the bike itself, the 31,000, is certainly a done deal in in my opinion, and therefore I think option C is the correct answer, right? Okay, question number 98. A agrees to sell 30 kgs, the principal of a strawberry, and it was, a below quality strawberry and some problem like that. But the principal clearly states that it is essential that there must be actual damage, right? In this case, there was no question, right? There was no question of any actual damage. So because there was no question of any actual damage in this case, therefore I think the safe answer is pretty simple, that there is going to be no monetary compensation, and therefore option B is the easy, straightforward answer in my opinion. Okay, question number 99. L agrees to sell M a consignment, and ultimately principle में क्या लिखा है कि both parties, the mistake has to be with both parties. In this case, both parties का mistake नहीं था. If you just go through the question, both parties का mistake नहीं था, because in this case L is a person who was already informed, right? L is a person who was already informed by his own assistant and so on, and therefore in this case we would think the answer must be option C, since L was already aware. Okay, question number 100. Question number 100 पे आ चुके हैं हम लोग, right? Now, this is a question about unreasonable events and, the doctrine of frustration, when something becomes impossible to perform, something that is out of control for a particular person, etc. This type of situation. Now, in this situation, ultimately, the problem that has arisen is that contract में ही, right? The contract itself had, certain clauses. The contract itself had certain clauses which provided, right, कि अगर pandemic होगा तो क्या होगा. So if you compare it with the general rule, right? If you compare it with the general rule of contract law, the specific clause in a contract has more value, right? The specific clause in a contract obviously has more value than the general rule. So, and that's the idea that we believe should be applicable, and therefore because the contract had an exception, we believe the answer should be option B, Bombay, right? It is not discharged because the contract contained a provision dealing with outbreaks, right? It contained a specific provision, right? Okay, question number 101. टाइगर पेट रख सकते हैं? बिल्कुल रख सकते हैं. नहीं रख सकते, बट ठीक है, किसी आदमी का थोड़ा लाइफ में जलवा था, उसने रखा. Now the principle, again, exception, I think that's the theme of this year's National Law University Delhi examination. This is the theme of AILET 2021, and I'm just going to go ahead and say it. इस साल के पूरा पेपर का थीम ही यही था, राइट? कि एक्सेप्शन ध्यान से पढ़िए. पूरे पेपर का थीम ये है, लीगल रीजनिंग का एटलीस्ट, कि एक्सेप्शन ध्यान से पढ़िए. सो अगेन इन क्वेश्चन नंबर 101 ऑल्सो एक्सेप्शन ध्यान से पढ़िए. द डिफेंडेंट कैन अवॉइड लायबिलिटी if they can show that the situation that caused the damage was as a result of an unforeseeable act of a stranger. Has a stranger done an unforeseeable act in this situation? Damn right. That is exactly what has happened here, right? That is exactly what has happened here. कि एक आदमी अलग से आके, right, while M was away, the neighbor S broke into his house, broke the tiger's cage, did God knows what the hell else, right? Therefore, M can escape liability for sure. M can definitely escape liability in this situation, right? Okay, question number 102. Mr. A vocal critic of certain policies, is the Queen of Asgardia. Again, very simple. अभी बताया है मैंने आपको. What is the theme of AILET 2021 legal reasoning section? What is the theme of AILET 2021 legal reasoning section? The theme was, and it clearly looks to be that once again, exception देखना है. What is the exception in this case? Only if there is a permission from a judicial officer. Only if it is with the permission of a judicial officer, then you can enter. Here, it was through the orders of the Queen of Asgardia. Can the Queen of Asgardia, the mother of Thor, no? Asgard hai, Asgardia jo bhi. I don't know, some of you must be Marvel fans, no? Marvel fans, drop us a like, Marvel fans, in on the chat box. I'm sure there are a few Marvel fans. Asgardia aa chuka hai fir bhi. Abhilash is saying, guys, show some sympathy for sir, like this amazing. Thank you very much, Abhilash. That is so kind of you. बस इसी बात पे मेरे आंखों से आंसू ना आ जाए. Queen's order is not the same. Queen's order is not the same as judicial officer's order, right? So, therefore, what? Marvel fan and anime fan. Aha, nice, Godel, nice. Therefore, it is an unauthorized entry in this case. Unauthorized entry, option C. Option C is the correct answer. This is definitely an unauthorized entry. Okay, 103. Again, this is pretty simple. Directly privity of contract rule has to apply. Very straightforward question. P और Q के बीच में कॉन्ट्रैक्ट है, Q एंड R के बीच में कॉन्ट्रैक्ट है, P एंड R के बीच में कोई कॉन्ट्रैक्ट नहीं है. Okay, so if there is no contract between P and R, P will not be successful in suing person R, right? PQ का contract, QR का contract, PR no contract, P cannot file a case against R. Simple, straightforward. Option A, we believe, should be the absolutely simple and correct answer. Okay, 104, again, absolutely straightforward, right? The conversation between two parties happened before K was the age of 18, right? Conversation सिर्फ हुई है, बात हुई है, right? K को बढ़िया भी लगा, जीवन खुशियों की तरफ बढ़ रहा था. But the contract ultimately happened only 6 months later. The contract ultimately happened only 6 months later, which means K was already competent to contract, and therefore option B absolutely should be the right answer for this question. 104, option B, Bombay. 105, and the last question for the day. The last question for the day, last question in the AILET 2021, right? Again, the second line of the principle, the last line of the principle continues to be the deciding factor. Mere intention to accept is irrelevant without communication. So acceptance communicate होना जरूरी है. Acceptance मेरे मन में है तो फिर फर्क नहीं पड़ता. यहाँ भक्ति की बात नहीं चल रही है कि राम मेरे मन में है, सीता मेरे मन में. ये नहीं हो सकता, right? ये नहीं हो सकता. You have to communicate the situation, and in this case you tried but you failed. बात हो नहीं पाई है, communication हुआ नहीं है. Offer acceptance is not complete. J will be unsuccessful since T's acceptance has not been communicated. Right? Is that clear, guys? Is that clear? Seems to be pretty straightforward, guys. Sir, 1K एक like हो जाए, मेरा भगवान से प्रे करूंगा. अरे That's very sweet of you, Godel. Kamaljeet, I have liked before the session. Aha, high five, Kamaljeet. So guys, that's what the answers basically look like. I hope all of you did well in the examination. We will come back with the final when the final answer key comes out for one more round of discussion with all of you. In the meanwhile, sahi prep hai to life set hai. Have a lovely evening ahead of you, everyone, and do review your answers. Do drop us, please, sir, please, WhatsApp number. I've already put it on the chat box. Prakhar, can somebody else please help out Prakhar if he's not able to receive my chat? Can somebody else please put it up, I guess, and help him out? Otherwise, just feel free to reach out to me on Facebook or anywhere else. I mean, I'll be more than happy to respond. Don't have to panic at all. All of us here at gradeup, including me, are only here to help you out. So so don't worry too much about it. Right? Okay, guys. Good night, everyone. Thank you very, very much. And I really hope this was very, very helpful. Thank you, everyone. Good night.